Good morning, everyone, and welcome to the second day of the Justice Center Summit. This session will be on Justice Center processes. We're going to get started shortly. I'm just going to give a little bit more time for people to sign in, so please be patient. Okay, before we begin, we'll start with a little housekeeping. For those of you who may be new to Zoom or haven't used it for a little while, this session is a webinar and all of the participants are muted and off of camera. Please look at the control bar at the bottom of your screen. If you can't see it, just scroll down a little bit farther. You'll see the very important chat function. We'll be posting information as we already have in the chat function with websites, information like that this PowerPoint will be available at the end of the session. And you can also ask questions that you may have of the presenters, and we will stop at the end of each section and at the end of the presentation to ask questions. Just one word that I'd like to say is that if you have very specific questions about like your specific provider or, just, one state oversight agency like the Office of Mental Health and how you get reports and stuff, put in your email. We will probably not ask those questions today, but we will get back to you individually. Finally, also take a look at the raise hand icon. If you are having any technical difficulties, please click on that and a WRI staff person will send you a private chat and help you out with any issues. To view closed captioning during this session, again on the control bar, you see the icon for closed caption. You can click on that to start viewing closed captioning. Everyone who attends this meeting will receive a copy of today's presentation and any related materials. It will also be available on the Justice Center's website. And we'll be sending you a survey at the end of the session, and we appreciate your thoughts and feedback on our summit. So that's it for me for now. I'm going to now turn it over to Sal Salerno, our Deputy Chief of Investigations.
Thank you, Davin. I appreciate it. Good morning, everybody. Like Davin said, my name is Salvatore Salerno. I'm the Deputy Chief of Investigations here at the Justice Center. I want to thank everyone for attending the summit this year. I also want to thank all the providers, staff, and family members for assisting us in our mission to keep people safe and advocate for people with special needs. So we're going to take you through the life cycle of a Justice Center case. And we can go to the next slide, please. The incident management report, taking the report. So our incident management, we actually started a new unit, the incident management unit, which was formerly the case intake unit. So now with the incident management unit also encompasses our 3 business day review unit as well. You can go to the next slide. The 3 reportable incidents, I'm sorry, please go back one slide, apologize. 3 reportable incidents are abuse, neglect, and significant incidents that always have to be called into the Justice Center. All 3 can be made via phone, web submission, or cell phone app. We often get questions about what a significant incident is or something should be reported. I recommend erring on the side of caution and report everything to protect yourself and individuals, and let our IMU unit take a look at it and properly classify it. And there is further guidance on our website in regards to that. Next slide, please. When a report is made, a trained representative collects information from the reporter and gives the caller an incident number. Reporters are protected by confidentiality laws, and all calls are recorded. The caller should keep that incident number for future reference if they're interviewed by our staff. Next slide, please. Information gathered from reporter. When you call the VPCR to report an incident, you'll be asked a number of questions. You'll not you may not be able to answer everything, but any information you have is important. In addition to your name and contact information, the types of information you'll be asked for include the details regarding the victim, the subject, the person who is alleged to have committed the abuse and neglect of a person receiving services, and the witness. You will also be asked to provide the details of the incident, including the date, time, and location, and the description of the incident and how it impacted the victim. You will also be asked to state the oversight agencies responsible and the name and address of the specific agency, facility, and/or program. Next slide. Continue for information gathered. In addition, you will be asked to confirm that immediate protections are in place for the victim, which can include the separation of the person receiving services and the subject of the report. If applicable, you may also be asked the name, title, and contact information of others who may have the same information as you. Finally, you will be asked if there's any information that may assist with the investigation or review of the incident. You are required to report even if you don't know all of the answers to these questions. We encourage you to report as soon as you suspect that an incident has occurred. Do not delay calling to gather more information. Your call may be instrumental in protecting the person receiving services. It takes a few minutes to discuss all of the details of the incident. We suggest that you call from a quiet location to facilitate communication. Next slide, please. Multiple reporter requirements. Multiple reports regarding the same incident are not required if the mandated reporter knows the incident was reported to the Justice Center already and they were named in a report as a person with knowledge about the incident. It saves the provider time as not to have to pull away staff from their duties to individually report the same incident. It also helps to, when if you're interviewed by one of our investigators, to mention that you knew that you were, in fact, added to the report when you were being interviewed. Next slide, please. After the call is taken, it's classified in two different ways, either as a reportable incident or a non-reportable incident. You have either reportable as an abuse and neglect or as a significant incident. Non-reportable will be general inquiries or non-Justice Center related items, and we'll discuss further numbers in the next slide, please. So last year in 2021, there were a grand total of 91,160 separate reports made to the Justice Center. Of those, 11,766 were abuse and neglect. 1,740 were death reports. Another 24,521 were significant incidents. 40,000 were non-Justice Center incidents, and another 11,000 change were non-incidents. The one thing to point out about the non-Justice Center incidents, of close to 12,000, came from OPW providers about COVID cases that were going on. So we track this information for OPW as well. Next slide, please. Significant incident classification. Each state oversight agency has unique definitions of significant incidents. The Justice Center has been working with all state oversight agencies to ensure classification of incidents adheres to regulatory standards for each agency. Again, like I mentioned, we get often asked about, certain significant incidents and if something should be called in. Again, I said, err on the side of caution or talk to your state oversight agency. Next slide, please. Incident management, the allegations review and assignment. Next slide.
Sal, there's a couple questions for you.
Sure.
Already. What types of provider agencies are required to report incidents to the Justice Center?
Pretty much all of the state oversight agencies that either are licensed or certified by the state. So, if you're you should be aware of your reporting duties based on that alone.
Okay, yeah. So all agencies that are licensed or operated by the different state oversight agencies. So can you provide any information about where a person might find out more about what a significant incident is?
Sure, Devin. Like I mentioned, we have that information and guidance on our website as well. So I know we're going to talk about our website. It will be provided later on the screen. So please, I encourage everyone, please, to visit our website. There's a lot of information on there.
Right. And as always, you can always visit the agency that licenses or certifies your program. They will help you as well with that. What happens if a call is made and it's not something that is considered a Justice Center reportable situation?
Right. So like we said, we do take in all that information. Non-reportable incidents are also kept for that reason alone. Sometimes it may not be something that's reportable to us, but it may go to another provider agency or another entity itself. So we store that information and share that with those providers or entities.
All right. And how do you determine that something is not a Justice Center incident?
Our IMU, our Incident Management Unit, does that along with triage, looking at all the information and deciding whether it falls into our jurisdiction and what the allegation itself is.
And how are false reports handled?
False reports are not new. As you know, we've done these types of presentations before. It is something that we are constantly dealing with. Every provider, every agency has that issue sort of going on. So we do look at the history of both the reporter, the victim, the staff member, and sometimes if there's something that needs to be flagged, we can do that, but we handle that as best we can.
Okay. There was a question about when the multiple reporter requirement changed. That changed a few years ago. So, as Sal said, if more than one person witnessed, just make sure that whoever reported it, you get the incident number. And then there's a couple other ones. Some of the questions about data we're going to be answering later, so I'm going to put those off. And we're also talking about law enforcement. So I'm going to stop for right now and continue on.
All right, sounds good. So back to incident management. We receive all cases of abuse and neglect and abuse and neglect death that are assigned to the Justice Center. We gather additional case information as needed, determines which case assignment it's going to go to, and ensures notifications are sent to law enforcement and district attorney's offices. Next slide, please. Our 3 business day classification assessment. It allows the Justice Center to conduct preliminary review of allegations using an evidence-based approach available right currently to OPW, OMH, OASIS, OCFS, and SCD at the time. In 2021, there was 4,163 reports that were assessed. 50% were downgraded to significant incident or non-Justice Center incident after receiving documents or further information from the provider. So it is pertinent to get back to us as soon as possible when we request that information. It will help us properly classify that. Next slide, please. It also increases accuracy of incident classification. It ensures for appropriate safety measures are readily enacted, a reduction in the length of time provider staff are out on administrative leave, a decreased number of provider staff unnecessarily placed out on administrative leave, and narrows the scope for investigative resources, ultimately reducing cycle time for all abuse and neglect investigations. And next slide. We'll get into a little bit of the investigations. Who investigates?
Sorry, Sal, we have a couple questions. Sure. Okay, so can you talk about, we accept anonymous calls. Why is that?
Well, we would never want to discourage anybody from reporting. So, of course, we will take anonymous calls, but we do inform people that if they are reporting anonymously, if they are a mandated reporter, unfortunately, it does not provide them with certain protections. So that we do encourage folks for that reason to provide their information or a contact information for at least the investigator to get back to them for either follow-up information or really to protect themselves.
Are notifications sent to law enforcement if the person who committed an act of abuse is a person with developmental disabilities? So I would assume that would be a person receiving services.
Right. We do not, that's not part of our wheelhouse itself. It's not something that we would do.
We have no jurisdiction over people who are receiving services. That's a different matter. There was a question about reporting significant incidents. Anything should be reported to the Justice Center if there is harm or risk of harm to a person receiving services, and that includes significant incidents. You can call your state oversight agency, but those significant incidents still need to be reported to the Justice Center. And last question for you, Sal, is can a person call OPWDD's IMU to report an incident and not have to call the Justice Center?
That is tricky. I mean, if they're reporting, I guess it could fall under, that's probably, it's kind of a tricky question. I don't know if I would automatically say that that covers them. I would say that they need to report it to the VPCR as well.
Yes,
so
I would say they have to report it to the VPCR. It would not cover them. Yep. So we're the database of record. All right.
All right. So we'll talk a little bit about investigations. Who investigates? The Justice Center investigators are assigned to investigate reports that allege or appear to constitute criminal conduct, the most serious incidents of abuse and neglect, all abuse and neglect incidents in OASIS, SCD programs, and in state-operated OCFS, OMH, and OPW facilities. Next slide. Many Justice Center investigators have previously worked in provider settings or have extensive experience before coming here. Many of the Justice Center investigators have and staff have family members served by providers under our jurisdiction. All receive continuous training, including various restraint training provided by the SOAs. What to expect during investigations. Subjects will receive a letter of notification from the entity conducting the investigation. There will be interviews, information gathering. It could be either from the Justice Center investigator or possibly from an SOA investigator, depending on who the case is assigned to. And next slide, please. Updated guidance for staff. Again, on our website, there's a lot of information here, but the provider staff tab gives you information about reporting incidents, including online training. The investigation process and the appeal process is all located here as well. The next slide, please. Our individual and family support unit guides individuals receiving services and families through the reporting, investigation, final determination, and/or criminal processes. It makes referrals and serves as liaison, promotes responsive and efficient communication, conducts outreach, tracks data and information. And the last slide for myself is understanding the investigation process, which we mentioned is on our website, in addition to plenty of other information and guidance. So I definitely recommend, hitting our website and taking a look if you haven't already. So I know before I turn it over to our acting general counsel, Krista Book, I'm sure we may have some more questions. Let me know if we do that.
You do have some more questions. How does the Justice Center determine to take a case or give it back to the provider agency to investigate?
So a lot of thought does go into this. Obviously, we cannot take all the cases just based on the sheer volume, but our intake unit, along with really looking at the egregiousness of the case itself and whether it falls into certain buckets, like we mentioned, state operated in those facilities, we would be taking regardless. So we follow strict parameters on certain things, but obviously anything that seems to be egregious or possibly egregious or something that we're aware of at a specific location, we would look to take that.
Thank you. What is the process if an agency disagrees with the Justice Center's determination after a 3 business day review?
Listen, we're always open for communication. If there's further information that was obtained or provided, feel free to reach out to us, via our intake email, and that can be discussed further. Classifications usually don't change unless there's really concrete information to tell us that it needs to.
Thank you. Can an agency appeal a finding of abuse or neglect?
An agency cannot, only a staff member who's accused of it. But we have had some cases where we've looked at it. If there's information that was not obtained up front, that was, not say withheld, but provided afterward, we could take a look at it. But that's really a rare occasion that we would do that.
Unless we made a category finding for a finding against an agency.
Or finding against the agency itself.
Yes. I'm just looking at a couple of questions. When reporting an incident, why is it necessary for the person who is reporting the incident to give their date of birth? I don't know if that's a question for you, Sal, or Krista, maybe. I don't even know if we...
I'll answer it. It's pertinent. Listen, we have a lot of people with similar names. We want to make sure we're talking to the right person. If we need to get back to you, there are all multiple, sometimes contacts with the same name in the VPCR. We don't want to call the wrong person asking for information. So we would prefer to know exactly who we're speaking to.
Right. And our database is confidential and protected. There is a question about self-reporting. Say a youth says, you just hit me and you're sitting right there and you didn't hit them. Should you report that incident or not?
If someone's making a statement like that, again, I would do that. We've had those cases where people have called in on themselves, and we've seen it go both ways, where clearly it did not happen and it was unsubstantiated, and sometimes, unfortunately, we've seen the flip side of that as well.
Okay. And I'm gonna ask I want to clarify for people, we do, if we hire investigators who've worked for a provider agency, we do everything that we can to not have them go back to that provider agency for a period of time so that we don't run into a conflict of interest. And I'm going to stop for right now and let you on.
Thank you. All right, so we'll turn it over to our acting general counsel, Krista Book.
Good morning, everyone. My name is Krista Book. I'm the acting general counsel here at the Justice Center. Previously, I was the director of the case review and closure unit within the Office of General Counsel here, and then the deputy director of incident management and investigations, and now for about 6 months, the acting general counsel. So I've worn a lot of different hats here at the agency. All right, so going to the first slide, I'm going to talk about when the investigation is complete. So when the investigation is complete, the Justice Center does review all investigations and makes a final determination and notifies all parties. We send out what we call our letter of determination, and we oversee corrective action plans, or CAPs, you might sometimes hear them be called, as appropriate as well. Next slide. Reports that are unsubstantiated, which would include false allegations, are not publicly available and they cannot be accessed by future employers. And all parties would receive that notice of determination that the report was unsubstantiated. Next slide. Substantiated reports of abuse or neglect are classified into one of 4 categories. So the first one I'll talk about is a category 4. Next slide. So there's 2 different types of category 4 findings. One is a category 4 that is made against a facility or a provider agency, not a custodian. So there's 2 different types of this. It's either that maybe there's staff that are culpable, but that is mitigated by systemic problems at a facility or a provider, or we know that abuse or neglect happens, and we're going to substantiate it, but we can't identify who the perpetrator of that abuse was despite a thorough investigation. So the mitigation by systemic problems, that's more when we're looking at kind of overall system failure. We can't say that any one person didn't do their specific job or a specific thing that led to this, but more that there needs to be kind of an overhaul of the entire system with respect to this one area, or maybe multiple areas. Or the abuse or neglect being substantiated, but the perpetrator can't be identified. An example of that might be someone with pica swallows something, and we know that it happened in the last 48 hours, and this is a person that's on one-to-one. Maybe they had 4 different staff with them during these 48 hours. And despite a thorough investigation, we can't figure out which of those 4 staff it might have been when this person ingested whatever the object was. Go on to the next slide, category 3. Category 3 is substantiated findings of abuse or neglect, but the conduct does not meet the definition of category 1 or 2, which I'm about to go into. Substantiated category 3 findings are not made publicly available and they cannot be accessed by future employers. So in other words, category 3 is the lowest of findings that we send out. Go on to category 2. This is conduct in which the custodian, this is the important language here, the language that's in our statute, where the custodian seriously endangers the health, safety, or welfare of a service recipient by committing an act of abuse or neglect. So basically, a category 3, there's 8 different types of abuse or neglect that we could find. Neglect, inappropriate restraints, sexual abuse, physical abuse, so on. So this is where we have all of the elements to meet a Category 3 finding. But in addition to that, we found that this seriously endangered the health, safety, or welfare of a service recipient, in which case it would be elevated to a Category 2 finding. 2 Category 2 findings in a 3-year period results in a Category 1 finding and placement on the staff exclusion list. However, the thing to know about that is that it has to happen in a certain order. The person has to be notified of the first Category 2 finding before they commit the conduct of the second Category 2. So sometimes we get questions about that, the timing of it, because someone could potentially have 2 Category 2 findings and not be on the staff exclusion list, depending on the timing of it. Category 2 findings that are not elevated to a Category 1 are going to be sealed after 5 years and not available. We can go on to Category 1. Category 1 is serious physical abuse, sexual abuse, or other serious conduct by custodians. There are 14 types of conduct defined in the statute. If you're interested, it's Section 493 of the Social Services Law. Mostly what we see that's going to be Category 1 conduct is physical abuse or sexual abuse cases, or neglect that's so severe that it rises to something that is very serious. So if you receive a Category 1 finding and you either don't appeal it or it's held up after appeal, you're going to go on the staff exclusion list, or SEL as we call it. So again, like I just had said, 2 Category 2s in a 3-year period or 1 Category 1 finding will place you on this list. Names of staff with a substantiated Category 1 finding are not made publicly available. So the SEL is not on the website to be publicly searched. Can move on to that slide. Individuals on the SEL are prohibited from being hired by any state-operated, certified, or licensed agency or providers that serve people with special needs. There are over 800 people on the staff exclusion list since our inception in 2013. And since 2014, there have been nearly 250 times that a check has resulted in a match and a provider has been notified that the applicant was on or pending placement on the staff exclusion list. So again, as I said, this isn't a publicly available check. This would be when someone's background is being processed for potentially hiring them in another facility, that we would notify that provider after a check that this person is in fact on the SEL. Okay, abuse and neglect categories. I saw a question pop up earlier during Chief Salerno's population about how many abuse and neglect cases are substantiated. So here's the answer with respect to 2021. Approximately 33% of our abuse and neglect cases are substantiated. So this wheel chart that you see up on your screen right now, this is just with reference to the 33% of the cases that are substantiated. So of those 33% approximately, which we have the number here as 2,965 cases that were substantiated, 74% are category 3s. So as you see, by far, the majority of cases are the category 3 findings, which are not publicly available and sealed after a period of time. Category 2 are 20% of our findings. Category 1 is 3%. So again, it's a much smaller number of cases, and it's very serious conduct that we find to get on the category 3 list. And category 4, which is either the substantiating against a provider in general or not being able to identify the perpetrator of the abuse or neglect, that is also 3% of our cases. Okay, next slide, please. We notify at the conclusion of our investigations. Again, like I said, it's called the letter of determination. We let the family member and or service recipient know what the outcome is. That's dependent on whether they have a personal representative or they are self-representing. We also notify the provider, the state oversight agency, and the subjects of the abuse and neglect. And the next slide. We also issue at times corrective action plan audits. So we do conduct audits of some of the corrective action plans for substantiated allegations of abuse or neglect. The audit finding letters would be sent to the provider and copied to the state oversight agency to share our findings and any recommendations made to reduce future risk of abuse and neglect or to improve the quality of care. That ends my slides, but I see questions popping up, so.
Yes, there are several questions, Krista. So let me start. Why are investigative summary reports redacted? Can the subject ever see an unredacted investigative summary report?
They are redacted in accordance with our law. So there is certain information that we cannot turn over, and that is written out by our law and followed by our law. So there's really not going to be a time that the subject is ever going to see a fully unredacted investigative summary report.
When waiting for a letter of determination, is there any way that provider agencies can reach out to the Justice Center and find out what the status is?
Yes, you can always reach out and we can let you know whether one has been sent or not, but we're never going to be able to tell you all of the steps that we're taking. So you won't get an answer like, we expected this will be mailed out in, approximately 3 days after a certain number of interviews are conducted. We can't get into that level of detail, but we can certainly tell you whether or not it's still in the investigative phase or if it's now being reviewed by counsel's office.
Thank you. What's the criteria that the Justice Center uses for substantiating allegations of abuse and neglect?
The standard is a legal standard, and it's called preponderance of the evidence. And what preponderance of the evidence means basically is it's more likely than not that it happened.
Thank you. And when does a subject find out that the case may be criminal in nature?
I'm going to leave that one more for when Rachel Dunn presents. I think she could answer that one a little bit better as she's our special prosecutor, inspector general.
Okay. Unless Rachel, if you want to answer that right now, you could maybe give a quick.
Sorry. Hi, good morning. I was just unmuting quickly. The subject is not always notified of whether or not it's a criminal case because we don't always know whether it's a criminal case. As we investigate, that could change depending on the facts that are uncovered throughout the course of the investigation. But the administrative cases that Krista was just discussing, those category findings, those are all universally administrative and not criminal findings. So when these outcome notifications are mailed to the subject, to the provider, and to the person receiving services or their representative, those are strictly administrative notifications. There is no similar matter or similar notification if an investigation is labeled as a criminal investigation.
Thank you. There were a number of questions about substantiated reports, especially category 3s and category 2s. Can future employers find out about a category 3 finding against a subject?
We would not send that information out.
It's right where we can't send it out by law. And so why can't victims or family members appeal determination of a substantiated or unsubstantiated allegation of abuse or neglect?
It's the law that provides for when an appeal may be taken, and the statute says that is for the subject of the report to be able to appeal. The
staff exclusion list, if provider employs somebody who is placed on the staff exclusion list, are they required to terminate employment for that person?
That's a difficult question to answer at times. The answer is it depends. There are things that are taken into account, such as whether or not the person belongs to a collective bargaining agreement, they're unionized in some way, and then there's different discipline proceedings that would have to be initiated and started, and a decision would have to be made by an arbiter.
Thank you. What if a person is placed on the staff exclusion list and they work at more than one provider agency under the jurisdiction of the Justice Center? Will that provider agency find out?
We would notify any provider that we have the person currently working at.
And just to clarify, there were a couple questions. All agencies under the jurisdiction of the Justice Center, so agencies that are licensed or operated by, OMH, OPWGD, et cetera, are required to check the staff exclusion list. So if you're placed on the staff exclusion list because you work at an OASAS provider and then you try and get a job at an OMH provider, you will not be hired if you're on the staff exclusion list. Are there any penalties for repeat occurrences for a staff member who has, say, multiple Category 3 findings?
There are not currently. It is up to the individual employer or provider as to what employee or disciplinary actions to take. But as far as, what the Justice Center recommends or being on the SEL, no, there's no stacking essentially of Category 3s. There's not the same provision like 2 Category 2s equaling a Category 1.
Thank you. I want to just, I know we put it up in the chat, but our website has lots of aggregate data about, the allegations reported to the Justice Center and the substantiation rate. And so that's really the good place to go and answer many of the questions that are coming up about data, but it's available in monthly and our annual report. And there has also been some questions about what information families receive. And just to say, it depends on if the family has, are they the legal guardian of the person receiving services? They would get a copy of the letter of determination. There's questions about, can families receive investigative summary reports? That can be a little complicated, and that's why we encourage you to contact our individual and family support unit, and they will help a family member navigate what they can have access to under the law. The law is very strict about sharing information. A lot of this is private health information, and that's why there is a level of redactions. So that's it for right now. Thank you, Krista.
Thank you, everyone.
Welcome back, everyone. Before we get started again, there were just a couple of questions that came in over the break or that I missed before. One of them was about staff being put out on administrative leave when an allegation is made. Some provider agencies put staff out on administrative leave. Is there anything the Justice Center can do about that? Do we require staff to be placed on admin leave?
Do you want me to take that one, Deb?
Sure, that'd be great, Krista.
No, we do not put staff on administrative leave. That is up to the particular agency. So the Justice Center does not have anything to do with whether or not someone is placed on leave or whether or not they're ultimately sent back to work or terminated, other than when the staff exclusion list comes into play on a Category 1 determination.
Thank you. And there were some questions about, what happens if corrective action plans aren't implemented at provider agencies, and also, if there's multiple Category 4 findings against a provider agency, what's the penalty? I just want to make sure that people understand that when the implementation of corrective action plans and overseeing that is done not just by the Justice Center. The state oversight agency that licenses, operates, or certifies the program has also a responsibility to look at corrective action plans, make sure that they're implemented And similarly, they would be the ones to make a determination if there are multiple Category 4 findings against a provider agency, if there needs to be any regulatory action or license action that is not the Justice Center. The Justice Center reviews the allegations that it receives. Last question, and I'm going to direct this one towards Chief Salerno. Can the Justice Center help a provider agency get the police to investigate if there's something that the provider agency feels strongly about?
If it's something that's leaning towards criminal, we would be working with them anyway. I mean, you could always reach out to us. Like, obviously, we couldn't, make a police department do something they didn't want to do, but we absolutely could reach out if it's something that especially if we were involved in as well anyway. They would more than likely be looking at it, or we would be involved with them as well. So it's no issue.
Yeah.
Reach out to the, I know it mentioned yesterday, the point of contacts would be, and I believe they were provided to everybody, either assistant chiefs in the different regions or the supervising investigators. I know that information was handed out yesterday. So that's where they should start. Yeah, they should start with the investigators or the supervising investigators in those offices. And then, if need be, to be elevated from there.
And then just the last thing about staff on administrative leave. Once again, it's up to the provider agency to determine when and if to bring a person back from administrative leave, whether or not the letter of determination has gone out. We always recommend, if you have questions, talk to the agency that licenses or certifies you. All right, I think Rachel is going to take it over from here.
Hi, good morning, everybody. My name is Rachel Dunn. I am our agency's Special Prosecutor and Inspector General. I've been fortunate to be here at the agency almost 8 years now, and I have been the Special Prosecutor and Inspector General since 2017. And I'd like to talk to you today a little bit about the appeals process. So this means what happens after the case is substantiated and after those letters of determination, the outcome of the investigation, after those notifications are sent, what happens next? So there is an appeals process. The subject of a substantiated report of abuse or neglect, regardless of whether it's a Category 1, 2, 3, or 4, the subject has the right to challenge the findings within 30 days. So this is an opportunity for the person who is the subject of a report to disagree, frankly, to dispute it, and an opportunity to present a version of events or pieces of evidence that they feel would contribute to a different outcome. So when we say appeal, we mean to argue against a substantiation. And again, this was something that was asked earlier, but to reiterate, a Category 4 finding is against a provider. So that means that the provider themselves is the subject of that finding, and the provider has a right to appeal that Category 4 finding. Every other category, 1, 2, and 3, the person, this particular custodian, typically the staff member, accused of the abuse or neglect in that substantiation, they have a right to appeal it. So we call that well, if you were to read the statute, it would call that a request for amendment, meaning we want to change what the substantiation was. We want to amend it. We typically simply call that an appeal. So I'd like to talk next on the next slide about how you request an appeal. It's actually incredibly simple, and we keep it that way by design. To request an appeal, if you are a subject of a substantiated report, all you have to do is tell us that you want to appeal. How you can do that is by writing a letter, or you can send it via email. In fact, if you go to our website, there's a form that gives you the very not boilerplate, but very basic types of information like your name, the case number, and simply that you want to appeal. That form also is really helpful to use because it asks for your email address, which is a great way to communicate with us in a very timely back and forth way. And it also presents you with an opportunity to share more information with us. What's really important about understanding the appeals process at the Justice Center, it's very critical that it be timely. And timely is a word we use in the law a lot, but what that means is on time. You have 30 days from the date of the letter to send in that request to appeal, that simple statement of I want to appeal. We get these all the time that are written on loose leaf paper. It does not have to be anything fancy or official. It doesn't have to be something with big lawyer words in it. Simply is, I would like to appeal. Here's my case number. Here's my name. Here's how to reach me. And that will cue the process. Again, I cannot emphasize enough, if you're the subject and you want to appeal, send that in as soon as possible, but understand that after 30 days, you will not have that opportunity. And all of this information can be found at the bottom of the outcome letter, that letter of determination telling you that you were substantiated. So make sure you read all the way to the bottom. Make sure you go to our website and follow that process. It is very simple once you do it. And one final note is that if you file a late notice of appeal, the law requires that our executive director herself actually has to review those late requests for amendments, those late letters, and it limits her from granting those late requests to extraordinary circumstances. So if you are filing a notice that you'd like to appeal, your letter after 30 days, it's really critical that you tell us what those extraordinary circumstances were. And we are rather limited on what the law will allow us to understand as an extraordinary circumstance. We're thinking things here like natural disasters or, situations in your personal life that couldn't be overcome, but we really need to know those details to grant those late requests. So one big takeaway here is make sure that you send that letter, that notification, even if you send it via email, you send it to us as soon as possible. So what happens in the process? It is a multi-stage appeal process. Next slide, please. Thank you so much. So that first number here on the slide, you request an appeal. Again, it's very simple. Just let us know you want to appeal. But as simple as it can be, I would say that every case benefits if you give us more information. So if you can provide more information as to why you think the substantiation was wrong, why you think there was evidence maybe we didn't get in the investigation, or perhaps an interview that you think didn't happen, or something that you think we conflated or were confused about, whatever it may be, the more information you can provide us with at the time that you request your appeal, the sooner we can take that information into account and the sooner we can include it when we evaluate the case. As I mentioned before, or as I think Krista mentioned before, Category 3 cases, they're not publicly available. Category 1 cases result in staff exclusion, and Category 2 cases are cases that can stack and go in. So it's important to understand also what you're appealing and what the ramifications of being substantiated, if that is upheld through the process, what that means. So think about that too when you send information in as to why you think the substantiation was incorrect. Once you send that in, the case goes to a unit here at the agency that I oversee called the de novo unit. And de novo, of course, is another lawyer word, but it means fresh. It means from start, from new. That means that a separate group of de novo attorney reviewers will look at the case, will look at the investigative file collected by the investigator and reviewed by the Office of General Counsel here. When that substantiation letter went out, they will look at all of that information, and they will also look at anything that the subject provides that is sent in with that appeal request, with that letter. So they will take a look at everything again. Because I think it's important here to understand that these reviewers are independent of the general counsel reviewers. So they don't work together, and by design they work separately. So the de novo reviewers will once again look at it and decide if that same standard that Krista described, the preponderance of the evidence, if that still continues to support a finding of abuse or neglect. And again, I feel like I've said this too many times already, but if you send in more information and it can be included in that first review, we will know sooner information you may feel we didn't know that led to that substantiation. So if you can provide it, that is always, always helpful on our end. Not legally required. You still have an appeal with a simple, I want to appeal. But again, this gives us a first opportunity to take a look at it. From that point, if the de novo reviewer decides that there is a preponderance of evidence, then that case substantiation would be upheld and the case would be forwarded to our administrative litigation unit. And from there, the administrative litigation unit would assign that to an attorney to litigate. And through that process, you would be notified of a pre-hearing conference, which is a telephone conference. It's not something you have to show up in person for, but you would call in and you would talk to an attorney from our administrative litigation unit along with an administrative law judge. And in that conference, the administrative law judge will answer questions about the process, will provide an opportunity to discuss the facts of the substantiation and of the case, and it will also be an opportunity to perhaps resolve the case, to understand the ramifications of the outcome, If it's a Category 3, keep in mind Category 3 is really, under our law, under the Justice Center statute, have no penalty. They are not available to the public, and future employers don't know about them. I personally like to define them as teachable moments. You know, I think everyone here easily understands that the goal and mission of the Justice Center is prevention of abuse and justice towards people and for people who have perpetrated or been victims of abuse. So when we say prevention of abuse, Category 3s are teachable moments in the sense that now we all know that something happened, but again, there's no real penalty to it, at least by our statute, by our Justice Center control. So that pre-hearing conference is a great opportunity to discuss all of that with the Justice Center's lawyer and with the administrative law judge. Also important here to understand, you do not need an attorney to be in this process. You don't need an attorney for number one on this slide here to submit your appeal request. The de novo unit review is automatic. You don't need an attorney to request that. It just happens. And at the pre-hearing conference, you don't need an attorney to represent you. It is entirely your choice if you would like to have an attorney. It is entirely your choice to choose whether or not you want to accept your union's attorney if you happen to belong to a collective bargaining unit and they provide you one. It's important, again, like I said, to understand you don't need to have an attorney. And as I stated before, it's really critical that that request come within 30 days. If you think you might want to hire an attorney to represent you, you can send the letter in on your own and then later ask an attorney to represent you, and they can send us notification that they represent you, and we can then direct communications to them. After the pre-hearing conference, if the case is not resolved, then a fair hearing will be scheduled before an administrative law judge. Attorneys from our administrative litigation unit will represent the Justice Center. You can choose to represent yourself if you are a subject, or you can hire counsel, like I said before. And the administrative law judge will permit both sides to call witnesses. Both sides will present evidence, and then the administrative law judge will make a decision. Those hearings are closed hearings. They are not public. And those hearings happen both in person and virtually. So if you're concerned about being able to travel for a hearing, we have a wide variety, but a strong background now in virtual hearings, and we can make sure that you have that opportunity to take your case to a hearing if that's what you choose to do. And then on to the next slide, the potential outcomes of an appeal. The first potential outcome is the case is upheld, exactly as the letter stated. The case remains substantiated at the same level. But at both that de novo process and also prior to hearing and during hearing, the outcome could be amended by a reduction. It could remain substantiated, but that Category 1 could become a 2, or the 2 a 3, or the 1 a 3. They can go down, but at no point in the appellate process here at the Justice Center can a case go higher in level. So if you are substantiated as a Category 2, you choose to appeal it and you go to hearing, there's no way that that outcome becomes a 1. It could stay a 2, it could go down to a 3, or it could be unsubstantiated. And in fact, if you read the decisions by our administrative law judges, which I will point out quickly are available on our website in a redacted form, the section on appeals and the appeals process has a link to administrative law judge outcome decisions, which are written decisions. And you can see in those decisions that the first step the administrative law judge takes when deciding a case is to determine whether or not the act itself was abuse and neglect. Was it physical abuse? Was it a deliberate and inappropriate use of restraint? Those types of conduct. And then once they determine that that was met, then they decide whether the category level was proper. In some instances, they will reduce the category level, or in some instances, the entire case would be unsubstantiated. Findings that are unsubstantiated entirely are sealed. The record is closed when the administrative law judge's decision is released. And of course, findings that are upheld as substantiated are not public, hence why these decisions are heavily redacted on our public website. There's no way to identify the perpetrator or the subject of the case, but they seal in the same fashion as when those letters happen. So meaning even if you take them to hearing, it doesn't mean that the case won't seal any earlier or later. It's still the 5-year time frame for these substantiated cases. And then finally, I know I've mentioned our website a couple of times now, but what you need to know about the appeals process, everything I just mentioned, is available on our website. There's a link to it there. It's rather, I would say, in more detail than I just provided here today, but it also notably has that form on how to file an appeal, and it has an email address for how to contact the appeals unit, so you can ask more questions if you need to.
Thanks, Rachel. I have a couple questions for you. The first one is, what law prevents a victim or a family from appealing a Justice Center determination about an allegation?
Well, it's not so much that there's a law that prevents them, it's just that there's no law that permits them. So when you think about due process in the law, it is the subject of a finding that stands to lose something, right? This is sort of universal in the law. So through this process, the subject is the one who stands to bear some kind of penalty, and that's why they have a due process right to request an appeal. So again, it's not that there's a law that prevents, it's just that the law that created the Justice Center, the statutory framework that created us through our enabling legislation, only permits subjects.
Thank you. And when a subject, they get the letter of determination, they receive the letter of determination, at what point can they get the investigative summary report or find out any more information about why the allegation was substantiated?
So when they, again, that 30-day time window is really critical. So I always tell people, make sure you file that letter requesting the appeal as soon as possible. When they submit what we call a 496 request. So the subject has the right under the law to request information about the investigation. However, it can oftentimes take a little bit longer than 30 days. So I, again, file that request for appeal and preserve your right to do it. But when you do file that appeal and it goes through the de novo process that I outlined, and you get, and the case remains upheld, you get a pre-hearing conference notice, and attached to that pre-hearing conference notice is a redacted investigative summary report. We built that into our process so that the subject would understand more about the investigation before they come to that pre-hearing conference, so they can make more informed discussion, arguments, and decide really what the basis for the evidence was against them in that substantiation, so that it's a more meaningful opportunity to decide what they want to do next with their case.
I believe we recently changed our letters of determination too, to provide a little bit more information about why something. Yep.
We did. So when the letter of determination comes from our general counsel's office, there is now an attachment to that, another page, so make sure you keep reading, that tells you a little bit more about the basis of the evidence that was collected by our investigations unit and form the basis of that substantiation. That comes with the letter, which is designed it's not the full investigative report, because many times those are lengthy reports, but it does give you a basis for what evidence was most critical in making that decision to substantiate the case.
Thank you. And do you have any statistics about how many appeals have succeeded when someone has appealed a decision or a determination?
We do have statistics. It's available in our annual report, and all of our annual reports are available on our website. I can say that our de novo unit, which is the team that takes that fresh look, that independent look at those cases, has a percentage rate around 15 to 20% based on, typically it's based on more information being provided by the subject than included. If you think more critically about preponderance of the evidence being more likely than not, when more information comes in, we may not have had an opportunity to get that during the investigation. Not everyone always wishes to be interviewed, but when you provide more information to us, it enables us to make more informed choices, more informed decisions there. And so we do overturn cases in that de novo unit and change them to unsubstantiations.
Thank you. Is there a penalty against staff who make repeated false reports to the Justice Center?
Well, I can tell you that there is an offense under our social services law called obstruction. So it would depend on why and how. It's not so much repeated reports that lead to that level of obstruction. I can also tell you that there is an offense in the penal law for making a false report to the VPCR, but there's an element of that offense which is gratuitously. So there needs to be a slight bit more than simply doing it. It's more about understanding why that person did it and what their true intent was. But certainly, we take a hard look at those, and those cases that we can move forward on, we would.
I'm going to take the last couple questions and just answer them. One is, who is defined as a custodian? You can find that in extreme detail on our website, but people who are working for provider agencies that are licensed, operated, or certified by the state oversight agencies. A board of directors or volunteers may be considered a custodian if they have regular and substantial contact with people. We leave that to provider agencies to understand who under their who they're working with would be a custodian. I would like to reiterate once again, if someone is placed on the staff exclusion list for an incident that occurred at an agency that, you employ that person, but the incident did not occur at your agency, that person should be terminated unless you have a collective bargaining agreement that would permit them to have an appeal for that. But the staff exclusion list, no matter where it happens, that prevents people from working in an agency. And the last question is, if a provider agency, sometimes they may disagree, or if we unsubstantiated something, what can they do? Always, 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 it is up to the provider agency to determine what kind of corrective action plans they want to take, what they want to do with that staff. We may unsubstantiate something, but that doesn't mean that you can't take disciplinary action against a staff. They may have violated policies that are very important to the agency, that are deal breakers. So it's up to the provider agency. Just because we unsubstantiate doesn't mean that a provider agency can't take any other actions. All right, that's it for me. I think Sarah is next, right?
Thanks, Davin. Thanks, Rachel. Good morning. I'm Sarah Delmarter, Acting Supervising Investigator for the Mortality Review Unit. We've been talking up to now about abuse neglect cases, and now we're going to switch gears and talk about mortality reviews. These reviews are separate from abuse neglect cases, and they follow a bit of a different process, and I'm happy to be able to talk to you a little bit about that today. Next slide. So for mortality reviews, we don't require that there's an allegation of abuse or neglect related to the death. Instead, the reporting requirement under executive law is that all deaths in residential settings that are licensed operators certified by OPWDD, OASAS, OCFS, OMH are required to be reported to the Justice Center. So all folks living in these settings that are state operated or certified under these 4 state oversight agencies require that the death is reported regardless of the nature, regardless of the cause or manner. Also, the statute extends, I think through regulation at the SOA's level, that we also take reports for any death where the person has been discharged less than 30 days from one of these programs. Next slide. So I'm sure folks in attendance are most interested in this piece. What is the provider's role? So the expectations are that the provider makes a report to the VPCR as soon as there's awareness of death. Sometimes awareness is delayed, especially in post-discharge deaths. Social worker might read an obituary and then report it to us, or family members might disclose a death after a follow-up call. We don't penalize folks for making a delay from when the person died to when they report. We just ask that as soon as the provider's staff are aware that a report is made. After that call report to the VPCR, the next step, the requirement, is that the executive director or their designee completes what's called a report of death form to the Justice Center. And our request is that it's completed within 5 business days. When we get these report of death forms, often there's a haste on the provider's part to meet that 5 business day requirement, and they might not have enough information to fill out the form. We're asking what medications they were on, when they saw their primary care doctor last, what their diet orders were. A lot of questions. I will say we've never given anyone a hard time for taking 10 business days and giving us a better report than to give us a report on day 1 and check unknown for everything. So utilizing the right people with the right information and getting this report to us timely is very important. And we appreciate any time that you can fill in information instead of checking unknown. Sometimes providers check unknown about various information pieces because the person was out of care. They had moved to a skilled nursing facility, or they were in the ER, they were in the hospital. We ask that you try to answer the questions based on your information about the person when they were last in your care. So that's another way that you can ensure that you're giving us the most information. Another provider's responsibility is to continue with conducting their own mortality reviews, their own investigation, their own incident review, and incident review committee accordance with the SOA regulations. So unless there's an abuse, neglect, death resulting case, we ask that you're moving ahead. There have been a couple times I've seen the provider falsely assume that we've taken on the review because we have a mortality case. And our reviews are concurrent with your reviews. The only time you would stand down is if an abuse neglect case provided a request for forbearance. Next slide, please. So we open a case and conduct a review for every incident report that we have jurisdiction for. I gave some numbers from the last 3 years. We're a small team of under 12 folks, and we process all of these mortality review reports. We, of course, had a very large spike due to COVID in 2020. But as you can see, 2021 continues to have higher numbers than we had pre-COVID. Next slide, please. So this breaks down the cases that were created in 2021 for mortality reviews by agency. And as most of you are probably not surprised, OPW had our largest percentage. OPW serves a large number of people across their whole lifespan, so we're not surprised the highest number comes out of OPWDD. Next slide. Now we're going to switch to 2020 and talk about reviews that were closed. We have good data on the cause and manners of death for those 2020 cases. And we put them into 3 different categories: natural and expected, natural unexpected, and then unnatural deaths. Our natural expected deaths are cases where the person's known diagnosis, their known prognosis, their current care plans lead us to not be surprised that the death was reported, that they're under the intended care, whether it be palliative or aggressive care, and that their diagnosis at this stage is not surprisingly causing a natural death. And that's about 27% in 2020. Natural unexpected means it was a natural process, an illness or something related to the body and different diagnoses. And maybe their death was related to a known diagnosis, but the death was more sudden or not expected to have occurred when it did based on where they were at in the disease process. This included all of our COVID deaths. It includes other infectious deaths, and it includes deaths where folks had known diagnoses, but the death was a little more sudden than expected. And it also includes deaths where maybe a diagnosis didn't come in until it was terminal because of it not being detected earlier. And then approximately 15% are our unnatural deaths. These cases include both in residential and inpatient treatment settings and post-discharge events that involve suicides, homicides, and accidents. And accidents include accidental overdoses involving such drugs as fentanyl and things like that in the community. And I think that drives that number a little higher than most folks would expect. 15% doesn't mean that folks receiving services are victims of homicide at 15%. It doesn't mean people in services are receiving suicide, accidents, and homicides at 15%. But because we accept reports up to 30 days post-discharge, that makes that number a little bit higher. Next slide. So what do we do? My team of registered nurses and program specialist investigators, they have significant experience in conducting a high volume of mortality reviews. They also have prior state oversight agency work experience, and they take their roles to heart. They really want to work collaboratively with you, the providers, to ensure the success of your own internal reviews and to help you identify areas for improvement. I saw a comment in the chat about, does the Justice Center ever support developing relevant investigative questions? And I can't speak for abuse neglect, but I can speak for mortality review. If you engage the reviewer in my unit early on, especially if they're a nurse and you don't have an access to a nurse, we can tell you what we're looking for. We can talk to you about what we're concerned about. And I think sometimes that's helpful to ensure that your investigation, when it's submitted 30, 60, 90 days later, and we're reviewing it, that we're all on the same page and there aren't surprises. We can do it both ways. You guys can work all the way through to your incident review committee and then submit them into your databases and submit them to our record requests. And then we can provide comments on whether or not we think you answered the questions that we were looking at, or we can have conversations through the life of our mortality case and really work together. I think when we collaborate, the results are better and there aren't surprises. So I encourage that. But what we do is we review the incident call reports for the death. We review that completed report of death form. We review the provider's incident review materials, investigations, statements, evidence collected. We review your incident review committee minutes, any corrective action plans. We also sometimes ask for specific provider follow-up, either questions to be answered or documents to be obtained to help us understand a specific piece of the case. And then we have avenues to understand the official cause and manner of death for all cases where the death occurs inside New York State. It gets a little tricky if the person crossed the border and died outside a state, but if they died in state, even if your review wasn't able to benefit from the official cause and manner, ours is, and sometimes we then have a conversation with you about making sure you're looking at certain things. Next slide. So most of our mortality assessments are able to close on assessment without a need for further review, and you get a basic closure letter that just says the mortality review has closed its review. But sometimes we do have findings, and sometimes we do have concerns, and sometimes we need to go further. So what do? One thing we do is we help identify reportable incidents inside these death reports. And those get called into the VPCR and delegated to field investigations the same way a non-death abuse and neglect case happened. We work with you as providers to report, or sometimes we directly report any reportable incidents that are found in the course of our death reviews. What are some of those things? If we identify a breach in duty that goes against care and safety practices of your agency or regulations or otherwise risks harm, that's not adequately covered in our mortality review. That requires to be classified through the VPCR. So that's when you will get a call from one of us, or you'll get notified that there was a reportable incident related to the deceased person. And that's because we found a policy, we found a supervision chart, we found a doctor's order, we found something that clearly wasn't followed, and that raises beyond us just having a conversation. It's something that we believe is reportable and has to go back through proper channels. So that's one thing we do. We help identify reportable incidents within investigations into mortality cases. Sometimes providers have completed their investigation. They've already found the problem. They've already put in a corrective action plan. And I'm sure you're frustrated when you get the call from us saying, this is reportable, it needs reported. And we often ask you guys to make those reports back yourself so that you can add the details that you know, and so that you can share that your corrective action plan has already been implemented. We also are then hoping that we're educating that in the future. If you're conducting your own internal mortality review and you identify something that's reportable, you really should take a pause and make that report at that time. Not wait till your investigation is written up and it's gone through IRC and you've gotten your cap. If you've got a breach in duty and your case is only classified as a mortality case, you really should be working to make sure that there isn't a higher level of classification for knowledge that you have on that case before you go further. Other things we do, we also send closure letters with recommendations. So sometimes we've either worked with you through the life of the case to identify some things that maybe weren't best practices or weren't followed, but maybe didn't raise to the level of a reportable incident. Or we found things because we've reviewed maybe 10 of this type of case and we know how other agencies are doing it and they're having successes. And so we'll issue a closure letter that actually includes a recommendation based on our findings. And those closure letters are also sent to the state oversight agency delegates so that they can be involved in supporting you in determining what steps, if any, are appropriate to take based on those recommendations we make. And then another tool in our toolbox, we also open what we call full mortality reviews. And those can involve a much deeper dive into records, interviews, site visits, environmental reviews, and they result in an official report issued at the end of our case from our medical review board, who is involved in these cases when we go full review. When we open a full review, we communicate that with you. We work with you as a provider to make sure that we're not overly intrusive and that we're scheduling things in a way that works for everybody, because our goal is really to make sure that we understand as much as we can so that we can make recommendations to prevent a similar reoccurrence. We've done full reviews for cases such as inpatient suicides to look at ligature reduction risks on inpatient units. We've done full reviews related to Hoyer lift accidents that resulted in deaths, fires, youths receiving a sudden medical emergency, such as a bowel obstruction or other medical emergency that resulted in a fatality. Those are the types of cases that we tend to get our volunteer doctors involved to help us come up with the best possible recommendations to support prevention. Next slide. So, and in closing, I just want to talk briefly about our medical review board. These are governor-appointed volunteer doctors in various specialties. We're allowed to have up to 15 members. They're available to us to support us to weigh in on medical standards of care and best practices, and they even provide valuable consults on cause and manner of death. So they've also been valuable resources to death-involved abuse neglect cases and non-death involved abuse neglect cases as well. They meet approximately monthly and are able to review up to about 4 cases at a time. And we currently have 9 members on our board. We have about 5 very active members. And I would be remiss before I turned it back over to Rachel if I didn't put in a quick plug that we are continuously recruiting. If anyone who is listening in is aware of a doctor who's strong in any of our person-served delivery systems and may be of value to serve on our medical review board, and you'd like to pass on the word to them to put their name forward, please do that on our behalf because we're recruiting this year. And with that, I'll take any questions that Davin wants to field me.
Yep, thank you, Sarah. There are a few questions for you. First one is, can the Justice Center assist in requesting documentation from a hospital for a death of somebody who received services or from a nursing home?
So that's a great question. We know that your investigations can become very limited. Sometimes you can't get autopsies, you can't get police reports, you can't get hospital records. Their ability to consent and give you those things is their legal department awareness of your role. We can't fix that, and we can't redisclose those documents that were given to us. But here's what we can do. We can have a conversation with you. Your QA can pick up the phone and call us. We can link you with the investigator, and we can say, I can tell you from my review of the hospital medical records, it looked like they arrived at the emergency room at this time. Their condition on arrival was this. Or in good faith, to help your investigation, we can share with you verbally that your investigation should look into the possibility of an accidental overdose inside your residence, inside the bedroom, because that's the direction that this is leaning towards. So we can't directly help, but we can definitely have conversations that can help make sure that while you're meeting your requirement to answer if your agency did everything they could, that if there's information outside of your agency that helps with that, we can do that. We also advise that you not keep your cases open because of an inability to get outside information. Your requirements, your needs to meet your SOA directives for your reviews are really about your services. So you close, and you can close with, should the hospital records become available, we will reopen. Should the autopsy become available to us, we will reopen. I think sometimes these reviews get stuck because they want more pieces of the puzzle, and you might not ever get them.
Thank you, Sarah. So OPWDD providers report deaths in IRMA. Do those death reports automatically go to the Justice Center, or do we have to do something else?
So the call report to the Justice Center is required no matter what. That is the original notification. But then filling out that report of death and updating the investigative process in IRMA is sufficient. There's some sort of, and I don't want to misspeak, whether it says submit, whether it says CQC or Justice Center, I don't want to misspeak, but those directly get routed into our inbox as a notification. So using IRMA correctly in accordance with its guidance gives us those report of death forms automatically.
Thank you. If we determine that a death is natural, expected, is there any process for a provider agency to ask us to appeal it and say it was death unexpected?
So expected and unexpected isn't really like categories 1, 2, 3s, and 4s, or substantiated or unsubstantiated. Expected versus unexpected kind of means how many resources we're going to dedicate to looking deeper into the case. If it's very clear to us that it's a natural expected death, we're probably not going to ask for 3 months of records. We're probably not going to interview a bunch of people. We're probably not going to go into full review. So it's not an official designation so much as it is natural unexpected means pretty much just that a nurse took a deep dive into that case. It's more a matter of getting the case the right resources than it is an official classification.
Thank you. How frequently do reports of death result in an abuse and neglect allegation?
Well, it's a low percentage because of the high volume of number of cases that we get. But that said, we probably identify and upgrade in one case a week, one case every couple weeks. But overall, out of the number of reports we get in a week, it is a small percentage.
Yeah, I think it's usually less than 100 a year of all.
And most of them, to speak a little maybe prematurely, but on the most recent spotlight on prevention, most of our upgrades from a mortality review to abuse, neglect, death involved revolve around delay in emergency care, recognizing that the person is moved dangerously from their baseline, following RN instructions, notifying the RN. And I know that the Justice Center did just release some wonderful guidance on supporting provider agencies and staff in that area. So our hope is that that could even decrease.
Thank you for that plug, Sarah. Does the Justice Center look into issues in hospitals, or, if something's uncovered, or does another agency do that?
Great question. So our team likes to think of themselves as one of the last advocates for the people that pass away. And in that, we don't let things go when we find enough information that maybe it was an emergency squad or ambulance or emergency room or hospital inpatient unit that we don't have jurisdiction, or nursing home where the fatal event occurred. We make those referrals to DOH, and DOH gets back to us with, at least at the high level, that our information informed their next survey and there were corrective actions made, or they checked in and it was a one-time thing. I think I go back to our OPWDD providers who hand off care to an inpatient hospital setting and say COVID restrictions didn't allow them to sit bedside, and then the person chokes on food. We absolutely are making those referrals to make sure that the correct state oversight agency is looking at these concerns.
Thank you. And one last question. When the medical review board makes preliminary determinations about a death is unusual, can you just talk about what more next steps might be for the provider agency to undertake?
Sure. So we use preliminary determination interchangeably with our assessments. And that means we're either comfortable that there's no reportable incident, or there's a reportable incident, it was identified and it got moved to the right channels to proceed. Or there's no need, or there is a need to go actually further with actual interviews and create a full review. So if preliminary decision is either everything has the elements for an outside report and it's been made and it's following its investigative path, or there's nothing to see here and we can close. Or if we dig deeper and we visit and we talk to people and we learn more about what happens, and we can make more recommendations and issue a report. So if we're issuing a report from a mortality unit, we let the provider know. we let them know we're opening a full review. If it's becoming reportable, the reporters, either the person who made the report from the provider agency, or they're notified that something was upgraded.
And I sort of misspoke. This is my final question for you. Who do you recommend should complete the report of death at the provider agency?
Another great question. So it's supposed to be at the executive director level or their designee. I think most agencies will find that someone at a program coordinator or case manager or involved nurse level probably has the most information. Sometimes it might need to be a collaborative effort because the questions might ask the last time they were hospitalized, what their diet plan is, what the circumstances of their health were over the last 90 days. So we do ask that the person with the most information that does complete the report is their name and their phone numbers on there so that we can follow up with them.
Thank you. We can continue on now.
Thanks, everyone. With that, I'll turn it back over to Rachel Dunn.
Thank you so much, Sarah. I'd like to talk to everyone quickly. The last topic for today's presentation, well, there's two, I guess, both with me. First is role of the special prosecutor. So the role of the special prosecutor here at the agency is to manage and oversee all of the criminal investigations. I touched on this briefly before, but next slide, please. Criminal investigations aren't so much about the person at that point. They're about whether the facts that were reported to the agency within that allegation, whether those facts, if true, would rise to a level of a criminal offense. So if that occurs and an arrest is made, that case could be prosecuted by the Justice Center or it could be prosecuted by a local district attorney. Chief Salerno mentioned this in his portion of the presentation, that we send notifications to district attorneys, which is true. In fact, we send notifications any time that investigation, those facts alleged in the allegation may constitute a criminal offense. We have a rather elaborate alert system that we use to notify district attorneys. And in some instances, county district attorneys have requested that we also notify county-based, county-wide law enforcement. So we do that as well. And our investigators, when they begin working on a case that we have designated as a criminal investigation, they also will make sure to reach out, as Chief Salerno suggested, to local law enforcement and make sure that everyone is working collectively and collaboratively. We also assist local district attorneys. The language in our statute is that we have a duty to cooperate and assist local district attorneys. Sometimes that means accepting a designation of their authority and acting as the prosecutor through the special prosecutor's office, and sometimes it means just assisting with pieces along the way, like, for example, working with a victim who has special needs and making sure that that victim is appropriately supported throughout the process, and working with our individual and family support unit, the victim advocates who work there, making sure that we provide support that way. Sometimes we do legal support in the background, whether that's working on an appeals case, a criminal appeals case, whether it's motion practice, a variety of things that we do in the background to make sure that these cases move forward. And it's important to know as well that all criminal cases, while the investigation may be labeled as criminal, they're always administrative. So anytime an allegation of abuse or neglect is reported to the agency, we have to have an outcome there. Historically, we would hold those administrative cases while criminal cases pended, resulting in criminal cases taking a long time to come through the Justice Center process. However, we've worked hard in more recent years to accelerate those companion administrative cases and to move those forward at the same time as the criminal cases. Some instances, it's just not possible, but for the bulk of cases that are moving forward now through the criminal justice system, through the court system, are also moving forward through the Justice Center processes, as we outlined before, through investigation, substantiation, and appellate process here, the Justice Center appeals process. So we work hard to make sure those move more quickly. We know that we get a lot of questions and feedback from providers about the length of those investigations, and we are always working hard collectively as an agency to move those forward as efficiently as possible. Next slide, please. So I discussed, the mandatory, statutorily obligated collaboration with district attorneys and with law enforcement. It's important to know here that the cases that come to the Justice Center that are reported to us through the VPCR, a very small percentage of cases are in fact criminal. when we look at the big numbers of just abuse and neglect, not even just talking about significant incidences, but just abuse and neglect, on average over the years, of which there's only been about 9 of those years, there's about 2% of cases that rise to that level. It doesn't mean necessarily that they result in arrest. It just means that when the outcome of the case is final, did we look back and think that there was possible criminal conduct that occurred? So we take roughly around 8% of our cases and give them this hard look. I think it's important to understand that the Justice Center's mission, at least from the Special Prosecutor's Office and from our statutory mandate, is to be a fine-tooth comb. Our job is to make sure that cases don't fall through the cracks. Historically, in law enforcement, cases involving people with vulnerabilities were hard to prosecute for a variety of reasons, among them being, the challenges of working with a victim who might not be able to give a statement or might not be able to testify in court, or working in situations where there's not a lot of witnesses. Those types of incidents or cases over the years, historically for law enforcement, were tough to work up. That's why our prosecutors have special training. That's why our investigators all have special training in working these types of cases. And so in conjunction with our investigators and our prosecutors, we are that fine-tooth comb to make sure that nothing that is that very small percentage of criminal conduct, that nothing gets missed, and that everything gets elevated through our notification process or through direct contact or working together to local law enforcement channels. And again, I stated this before on the last slide, criminal cases do take longer to close. Sometimes that is beyond our control. Sometimes that is because of things that are going on within the court system. It gets a little bit complicated because subjects in criminal cases enjoy more rights. They have more opportunities, and we want to make sure that they have an opportunity in the administrative section as well to present a version of events. That doesn't happen in the criminal side. There is no right to have the Justice Center force a subject in a criminal case to give a statement. So sometimes that distinction creates a lengthier process for the criminal cases. But again, we've worked hard in recent years to make sure that we can accelerate those when we can. And then the last section, Davin, I don't know if there's any questions there or if you'd like me to move forward.
There are a couple of questions. Thank you, Rachel. Can a Justice Center determination result in civil actions, especially if it were a Category 1 or Category 2 finding? And if so, are investigative notes or summary reports entered as evidence into a civil suit?
I actually can't speak to that because it's against the prosecutor's code of ethics to comment on the strength of civil cases while a criminal case is being investigated. So unfortunately, I really wouldn't be able to answer that question. I don't participate in the lawsuit process as people tend to think of it, where somebody might sue a provider. Prosecutors, by ethical rules, we don't participate.
You. And what can you just explain once again, what determines if a case is criminal or not?
Well, we have a process where our incident management unit, which is the section that Chief Salerno described, they review a set of facts as they are reported to us, and they look at those facts and they think, well, if these facts as true would constitute a crime. So again, we're not deciding at that point that they are in fact true, but we're saying, okay, if this allegation would constitute a crime, we're going to mark that case as a SPIG-led case. SPIG is the lovely acronym that stands for Special Prosecutor Inspector General, and what that means is that a prosecutor from our agency will participate in the investigation and look at the investigation and will search with that fine-tooth comb to see if a crime occurred. So what we're looking for here is very, very, very serious allegations of abuse and neglect. We're also comparing that with the crimes in New York State's penal law. So if they rise to those levels, it's significantly more than we need for abuse and neglect. It involves matters, things like intent, it involves severity of injury, it involves so much more than just the social services law. But again, it's the very, very, very serious cases. And within that, even if we classify a case as a, quote, criminal case, the investigation may reveal that it's not of that level, and it may also reveal that it didn't occur. So that early label really doesn't actually mean that much for terms of outcome.
Thank you, Rachel. That's it for now.
Okay, so the final section of today's presentation is the prevention of abuse and neglect. Next slide, please. So I'd like to talk quickly about something our agency is incredibly proud of, and like I said before, the mission of the Justice Center isn't just about justice for victims of abuse and neglect and holding perpetrators accountable, but most critically perhaps it's about the spotlight on prevention. How do we take something that happened and prevent it from happening again? So over the years we've developed a variety of tools, all available on our website. The link is here on the slide, that provide really helpful tools for providers specifically. I think also for family members to have a better understanding of what the Justice Center does and why we do it. But really for providers, we have a section on agency self-assessments. They can help you take a hard look at your practices and protocols and what those practices and protocols may or may not lead to. You know, from our experience, can we help you create better practices and better best practices? Absolutely. And we provide those tools through the self-assessments. And then, of course, even without an assessment, you can take a look at our best practices for abuse-free environment. Those are strategies that we have gleaned from working a number of investigations over the years, tools for prevention that have worked elsewhere or have worked in aggregate as we look across the entire state, across all 6 state oversight agencies, that create these strategies that we want to share with you to create safer environments at every provider throughout the state. And then finally, the Code of Conduct is something, when the Justice Center was created, that established an ethical guideline for all people who work and provide care for individuals receiving services. It comes with training for providers to offer to their staff. It also comes with information about compliance and how you can work with your individual licensing or operating state oversight agency to make sure that you're in compliance with the codes of conduct as are mandated. And then next slide, and please. Our final slide today is on Spotlight on Prevention, which Sarah was kind enough to give a great intro to. The Spotlight on Prevention is something that I personally actually am very rewarded by, because over my years as a prosecutor, as working in other areas, before I came to the Justice Center, I read lots and lots of police reports, and police reports don't have any section for how do I prevent this from happening again? Well, every Justice Center investigation has a section for that. It has a section on prevention. It has a section on how do we take something that could have been very, very severe or could have been a near miss. How do we take a teachable moment? How do we take that and make sure that it doesn't happen to somebody else? And so over the Justice Center's existence, since we were created in 2013, we have realized that some things that we were seeing repetitively through different investigations statewide were more common, and that if we could come together and form some best practices on how to prevent these specific types of abuse or neglect, how could we do that? And so we have designed toolkits. There's 9 listed here. I think the first one we ever did was probably the dangers of being left unattended in vehicles, and then over the years they've evolved into the more recent responding to medical emergencies that's circled here on the bottom left. As Sarah mentioned, when we see that in cases, we want to help providers develop better tools and better best practices to prevent these things. I think you can really think about these toolkits as an amazing opportunity for providers to benefit from sometimes tragic and hard lessons that were learned elsewhere, so they don't have to experience those hard lessons themselves. We firmly operate under the belief that providers want to create absolutely therapeutic and safe and caring environments for all of the people that they support who receive services, and as for their direct care as well for their staff. And these toolkits are a great way to learn more about things we have realized over the years that you could benefit from. So I really do encourage you, check out the website. These are all available there. And with that, I think that is the conclusion of today's presentation.
Thank you, Rachel. We have just a couple questions to end with. The first one, I think I'm going to direct towards Krista. If a provider agency disagrees with a letter of determination around an allegation of abuse or neglect and wants to find out more about the Justice Center's reasoning, maybe their incident review committee would like to look at the case differently, who can they contact?
So I would start with the information line here at the Justice Center. That number is on our website, and I think actually right here on this slide. So you can start at the information line and they'll get you to the right person, which will likely be someone from the Office of General Counsel who will call you back.
Thank you. If you don't hear, keep on calling. Don't suffer in silence. There was a question from someone about if, someone is receiving self-directed care, do the staff that may be selected to work with a person, are they required to be checked through the staff exclusion list? The answer to that is my understanding it depends. If the person is going through an agency that's licensed by or certified by OPWDD for the self-directed care staff people, then that would go through the staff exclusion list. We don't currently, under the law, it's not permitted to have, there's just a very specific finite number of types of programs that can check our staff exclusion list. We have, and we covered it briefly yesterday, we have put forward legislation to increase the number of people who can check the staff exclusion list, but right now we have a small number. Final question, how are human trafficking cases handled for either children or adults?
I'll take that one.
Thanks.
If that's okay. Human trafficking cases are something that we take a very hard look at here. I mean, we take a hard look at all of our cases, but human trafficking is something collectively as a law enforcement community, we continue to learn more and more about the nuances of those investigations. Our prosecutors are members of, and our investigators as well, are members of anti-human trafficking task force throughout the state and various regions. What's important about that is when you work in a task force, you have a dedicated channel towards working with other law enforcement resources in a given area. And when you look at our social service law definitions of what constitutes sexual abuse, the conduct that would be comprised within the trafficking of individuals for sex purposes, that would be included within our sexual abuse substantiation as well. There's actually an overlap between the penal law and the social services law in that one instance. So any time that's even suspected, I implore you to call our Vulnerable Person Central Register and to give as much information as you can so that we can begin working those as soon as possible.
Okay. Thank you. That's the last question. There were some questions about where links are. You can go to the Justice, until you get the PowerPoint slides sent to you. If you go to the Justice Center website, it's really easy to navigate. You can click on the prevent abuse. You can click on, providers and find out lots of information. You don't have to wait for the slides to come. So thank you all for the great questions and the participation and interest today, and have a nice afternoon.